A very good morning to one and all present here. I, Tanushri, on behalf of CMR University, School of Legal Studies, welcome all of you to the third day of our Faculty Development Program 2024. As we are about to begin the first session for the day, it is my absolute honor and privilege to introduce our resource person for the session, Professor Dr. P. Ishwara Bhat. Sir has been the former Vice-Chancellor of Karnataka State Law University and the West Bengal National University of Juridical Sciences, Kolkata. Dr. Bhat holds MA, LLM, and PhD degrees from Mysore University and has a distinguished career in legal education. Dr. Bhat has taught at the University of Mysore from 1984 to 2011, where he served as Dean of the Faculty of Law for 3 terms and as acting Vice-Chancellor. He has also taught at Karnataka University, Dharwad, and MK Law College, Hassan. Specializing in constitutional law, Dr. Bhatt's areas of interest also include administrative law, law and social change, water laws, research methodology, world trade law, intellectual property rights, and NPO law. He has contributed to drafting several legislative bills and university statutes. Sir, I humbly request you to come to the podium to address the gathering.
All the respected faculty members and other reviewers. The topic that I have chosen for a faculty development program lectures is a pluralistic theory of constitutional interpretation and eclecticism. For interpretation of the Constitution, several principles of interpretation or several methods of interpretation are employed. The courts make use of the text of the Constitution, history, purpose, structure, and ethos. These 4 or 5 factors which form important arguments in the Constitution interpretation become inevitable, or they are very much required for the reason that the courts gather from various sources how exactly the meaning of a particular constitutional provision could be brought out and constitution could be interpreted accordingly. That is the main idea of plurality of constitutional arguments or a pluralistic theory of constitutional argument. It believes that no single method of interpretation could be regarded as a sufficient or adequate or full-fledged to bring out the meaning of the Constitution. The interpreter has to make use of several methods of constitutional interpretation. Whereas even for interpretation of legislation also, it is essential that the courts have to look into all those factors like history, text, purpose, then a structure, and all those things. See, the second part I am going to discuss is eclecticism. Eclecticism means search for the best method or the best argument, or it is the approach of identifying or choosing the best method among different methods, or combining 2 or more methods so that best possible interpretation could be provided by the interpreter. That is eclecticism. About that aspect, I will discuss later. First, I will discuss about the pluralistic theory of constitutional interpretation. Why we should have this scope for multi-method interpretation or pluralistic methods of interpretation. This question can be answered by giving several reasons. The first reason is that the resources that are available for a constitutional interpretation are several. text provides the linguistic snapshot. Then the words used in the text have their own arrangement, and they have particular historical background. Further, contextualizing the words used in the constitution becomes very much essential to know the meaning of it. So context is very much important. You might be knowing that the latest judgment in the Article 370 is mostly based on contextualism as a tool of constitutional interpretation. Then the resources that are used by the interpreter will be external aids or internal aids. Internal aids are several. Preamble, margin note, and so many other internal aids are there. External aids are also several. There is a constitutional history, constitutional debates, then a dictionary, international law, foreign law, or encyclopedia. These different resources are there. Some resources are having a more democratic content or element, but some have democratic deficit. They do not have adequate democratic base for all such propositions. That's the type of possibility. For example, when a mere dictionary or encyclopedia or a foreign law is cited, we do not come across a democratic element in it. But constitutional debates, it has a full democratic element. Whatever will be the content of this democratic element, all these resources are to be taken into consideration when these resources are several, multiple. It is essential that the interpreter has to look into all these aspects, because any type of interpretation which can throw light on the purpose or throw light on the moral vision of the constitution or ethos of the constitution can be brought to the forefront only by making reference to all these resources. This is the first reason for having plurality of arguments in a constitutional interpretation. The second reason is this: constitutional morality or constitutionalism is a principle, or it's an approach from which constitutional interpretations of flow gorgeously. Constitutional interpretation largely makes use of this concept of constitutionalism. Constitutionalism, when put into application or practical work, then we come across a constitutional interpretation. So constitutionalism and a constitutional interpretation are interconnected. This constitutionalism is developed on the basis of people's support to the constitution, or the historical background in which the constitution emerged. That points out how people stood behind the constitution and they made the constitution. Who are these we the people? In India, we find that we the people are not just a human mass. They represent different religious, linguistic, ethnic communities, or different class of people, but determined to have a harmonized collective life in the nation, in the budding nation. That kind of participation becomes very much essential. So, when the constitution is a product of the wisdom of ages, we find that beneath the constitutionalism, which is the basis for a constitution, there is some collective decisions which cannot be ignored in the process of constitutional interpretation. That is why interpretation of a constitution is to be done in such a way that all these multiple factors that India is a country with the poorer sections of the people or a certain segment of the society are backward or they are educationally they are lagging behind. All these types of factors shall be taken into consideration. For example, when we interpret the provisions related to fifth schedule, the fact that the tribal community has certain features which ought to be taken into consideration will enter into the mind of the interpreter. That becomes very much essential. That is why the interpreter has to take into consideration all these sociological, economic, political, and other factors. Because constitution is a parallelogram of socio-economic forces. It emerges from that kind of force. That is why due consideration of those forces becomes very much essential. See, the idea of federalism, idea of multiculturalism, or various other factors of diversity are to be taken into consideration. Federalism has its own history in India. See, 562 princely states had to be merged. Then various linguistic communities were to be accommodated. Various ethnic communities had to be accommodated. So Indian federalism is something known for reflection of multiculturalism itself. That's why in the course of interpretation of the constitution, all these multiple factors shall be taken into consideration, and it's a plurality of arguments related to constitutional interpretation becomes inevitable. The third reason is this: whereas external aids in a constitutional interpretation, like a constitutional assembly debates, foreign precedents, etc., cannot be treated with a uniform standard, and they have to be treated differently, and we have to take into consideration those factors. The fourth reason is this: always a multiple method approach is profitable, or it is superior over single method interpretation or single method approach. Even in the field of research, we find that monodisciplined research has serious drawbacks, whereas a transdisciplinary approach in our research, whether it is a multidisciplinary or interdisciplinary, that approach has a lot of advantages, because the researcher will be looking from a different angles or different perspectives. In the same way, when a constitutional interpreter interprets, he should examine from a different perspectives. See, social, economic, historical, cultural, and other angles shall be taken into consideration in the course of interpretation. There is a proverb that a single light will always have a shade behind it. That is a well-known proverb. But when there are multiple lights, that shade is overtaken, or it is flooded with light, so that there will not be shade at all, because from a different angles when a particular object is looked, then there will not be shade, or there will not be any area of ignorance. Suppose we equate shade with ignorance, that is the thing that we can say. In a sociological research, we come across the idea of a triangulation, looking from a third angle or third perspective. So there is a dispute between two parties about land, about the uh, border dispute between two parties is to be tackled. How exactly that should be done? The land surveyor will trace some other survey mark in the neighborhood, and from that survey mark or survey stone, he will take measurement and will identify whether particular line, border line between two landowners stands as it is, or it ought to be altered. About that, he will give suggestion on the basis of drawing lines from different survey numbers. See, in the same way, here also, in the field of research and in the field of interpretation, triangulation brings a perspective from a third angle. That's why it is a triangulation. See, when alternative viewpoints are put forward, then interpretation becomes objective and rational. That is the advantage of multiple methods of interpretation. Now, suppose only from the angle of text, interpretation is conducted by the interpreter. The court looks only to the text. Say, A.K. Gopalan, only to the text, and it does not go beyond that. So, about the moral ethos of Article 21 to protect the personal liberty, that is not taken into consideration, or its relation with the say freedom of movement is not taken into consideration. We find that there is a defective approach in sticking to that text. So the history is also taken into consideration. See, in an NGSA case or even an earlier case relating to judicial appointment, especially the second judge's case, which was a crucial case, there the court said that one has to take into consideration constitutional convention that in all appointments hitherto, there is the appointment of judges. The view of Chief Justice of India is taken into consideration positively, and it is relied upon and acted upon. See, there is no deviation from that approach. Primacy of the view of Chief Justice of India is the factor that influences the process of appointment. That is the practice followed for a long time. If that is so, then the text of the Constitution, which says that in consultation with the Chief Justice of India, is to be interpreted as something after getting the consent of the Chief Justice of India. To have consultation means to have consent also. That type of interpretation was adopted. See, this interpretation is not a textual interpretation. If a text is the criteria, the court would say that consult. Yes, the president has to consult, that is all. And he need not abide by the advice of the Chief Justice. That would be the approach. But the court said that it is the long historical practice supported by Constituent Assembly debates. Because in Constituent Assembly debates, Dr. B.R. Ambedkar categorically stated that the view of Chief Justice of India shall be considered as a primary one, primordial, because he is the fountainhead of the whole judicial system. He knows best. See, he knows best about the judicial system. That's why his view is to be taken into consideration. See, preferring the history over the text or the approach here, and suppose the text was the only basis, the court would have simply taken the view that yes, the view is not binding. The first judgment, first judge's case, that would have been simply continued, but it was not done. That's why multiple methods of interpretation provides for a opportunity to verify, opportunity to cross-check, and opportunity to have triangulation of different viewpoints. The fifth reason for a pluralistic argument is that almost all constitutional writers, it may be famous Durgadas Basu or H.M. Shirvai or Joseph Story, Thomas Cooley, Lawrence Tribe, Philip Bobbitt, Peter Hogg, or Hanks. Any of these constitutional commentators, they have relied upon more than one principle of constitutional interpretation. Bobbitt, in his famous book, The Constitutional Faith, he lists 5 important tools of constitutional interpretation: that is history, text, structure, purpose, ethos. It is only with these 5 principles that a constitutional interpretation will become complete. Any kind of dispensing with any one of the arguments will be flawsome according to Philip Bobbitt. But Philip Bobbitt did not go for combination of methods or prioritization of methods. He considered that all the tools of interpretations are on equal footing, and the judicial discretion to balance different constitutional arguments is something to be put into action or put into service, and prioritization among different tools of interpretation cannot be considered as appropriate. That was his argument. Now, coming to theoretical explanation about this pluralistic arguments. Yes, Chief Justice Marshall in Marbury versus Madison pointed out, it is emphatically the provincial duty of the judicial department to say what the law is. What the law is something to be told by judiciary. See, outcome of a judicial process is also law. See, when a judiciary lays down a judgment, or when it pronounces a judgment, it is also law. So, when that law making in general has the process of using several processes, like use of text, history, structure, purpose, etc. It is inevitable that in the course of judicial lawmaking also, there ought to be application of those principles. For example, when a legislature enacts a legislation, it takes into consideration, or it ought to take into consideration, several factors: historical factors, then a law commission's report, or a special committee's report, and so many other factors, including judicial observation, etc. Of course, the latest legislation related to Bharatiya Nyaya Samhita, etc. There are criticisms about the non-application of law commission's service, etc. But it is essential that there ought to be this thinking process, which is widespread and which is done by different bodies, and appropriate research is essential for those purposes. When a judiciary does that in the course of constitutional interpretation, it has to make use of all these methods, and it has to take into consideration these factors. See, Justice Holmes said that the case before us must be considered in the light of our whole experience and not merely of what was said 100 years ago. See, it is essential that the entire experience of the mankind or the nation should be taken into consideration in the course of interpreting the law. Thus, the judge in arriving at such a conclusions in a constitutional interpretation should make use of all such sources of constitutional interpretation. Thus, it's essential that these inputs should form the foundation of constitutional interpretation. Richard Fallon also made that observation that although constitutional arguments are distinct and several, all the arguments are to be properly addressed. They are to be taken into consideration. Philip Bobbitt said that there is no need, there is no possibility of balancing or prioritizing, etc. But there ought to be consideration of all the constitutional arguments. The second explanation, there is a theoretical explanation in support of a pluralistic theory, is that the viewpoints that were developed by scholars in the form of different theories shall be made known to the judges, so that judges will apply their mind to the theoretical underpinnings of those propositions or those philosophical arguments, and come out with some judgment which is quite convincing. For example, D. Conrad, famous German constitutional scholar, wrote one article that Parliament has limited power of constitutional amendment. It has no power to amend the basic or essential features of the constitution. Soon after I.C. Golaknath case, he wrote this article. Of course, he delivered a public lecture, Alladi Krishna Swami endowment lecture in Madras University, and subsequently it was published. And this small article inaugurated the idea of a basic structure for the first time. See, in a latest judgment, Janhind Abhiyan case, Justice Badiwala makes a and Justice Dinesh Maheshwari also, they make a elaborate reference into the influence of D. Conrad's article upon Keshavananda judgment. Keshavananda judgment was built up on the basis of this central theoretical consideration of Conrad's article. What was the core idea propounded by Conrad became the central proposition of the majority judgment. Of course, some judges acknowledge, some judges did not acknowledge, but of course, some of the books and articles on Keshwananda judgment, there is a reference to the influence of D. Conrad's article. See, he developed that theoretical argument. The theories developed by the juries will have their own influence upon the constitution, constitutional interpretation. That's why when a plurality of arguments are put forward by various constitutional scholars through their theoretical arguments, they will have impact upon the process of constitutional interpretation. Another explanation about the theory is that different theories of constitutional interpretation arise from different conceptions of constitutional authority. See, different cases develop their own theoretical considerations or their own arguments, or they develop certain doctrines. These doctrines are to be considered by the subsequent judiciary. Just like theories have their own impact, the doctrines developed in earlier cases, they are called as precedents, will have their own impact upon a constitutional interpretation. That is why multiplicity of constitutional arguments is a factor that should be properly and efficiently addressed by the judiciary. Of course, there could be an argument where constitutional interpretation is to be influenced by theory. What is the relation between constitutional theory and constitutional interpretation? There is a closer nexus. It is not possible to say that always a constitutional interpretation should be anchored to constitutional theory. Constitutional interpretation transcends a constitutional theory. That is a fact. But still, the relation between constitutional theory and constitutional interpretation is something that ought to be adequately taken into consideration. How exactly this pluralistic theory is put into practical application? We come across a number of judicial decisions where pluralistic theories are put into practice. In a NCT Delhi case, Chief Justice Deepak Mishra states that principles of constitutional interpretation occupy a prime place in the method of adjudication. Principles of constitutional interpretation occupy a prime place. He does not say principle of constitutional interpretation. He uses the word principles of constitutional interpretation, plurality. So there is not one single method of constitutional interpretation. There are multiple methods of constitutional interpretation that will be taken into consideration. See, in a RC Bodial case, Chief Justice M.N. Venkatachalaya considers that Constitution is the embodiment of conceptual framework yes, each word in the Constitution embodies conceptual framework. That was his view. See, in the second judge's case also, rules of interpretation were considered as forming a sui generis system. That's in a sui generis system like a constitution. The interpretation principle will not be same as that of ordinary principles of constitution or ordinary principles of statutory interpretation. What I mean is this: there is a lot of difference between interpretation of a legislation and interpretation of a constitution. Interpretation of a constitution is a special situation. It's a because constitution is a sui generis. It's a supreme law of the land. And in interpreting it, we have to adopt an approach which is most advantageous to the people, which can bring the welfare to the people. See, the words used in the preamble, justice, liberty, equality, etc. All these are ultimately connected with welfare of the people. Justice for what? Ultimately, justice is for bringing welfare. That is the ancient notion of justice. When we take into consideration the purpose underlying the constitutional structure or a constitutional mechanism or a constitutional framework, we find that ultimately the constitution intends to bring a better world, good governance, better human rights protection, good harmony in the society among different classes, and also cooperation between different levels of government, federal and state government. See, the idea of a living tree propounded in a Canadian Constitution, in the famous Edward case, the Canadian Supreme Court evolved this doctrine that Constitution is a living tree. It grows, and the natural limits up to which it grows should be taken into consideration in the course of interpretation. See, even relating to Indian Constitution, Daniel Austin makes one observation that liberty, the plant of liberty, was put into the Indian soil with a great expectation that it will one day blossom to the full extent, etc. Thus, purposive character of the Constitution and purposive character of each and every concept in the Constitution is something that shall be taken into consideration. So, when a purposive interpretation is to be adopted, actually the Constitution, the concerned judges do take into consideration those factors. In a S.R. Chaudhary case, purposive interpretation was adopted. See, there was a case relating to one of the constitutional provisions which provide that the chief minister can appoint enough of the ministers only for a period of 6 months. In case that person is a non-legislator. A non-legislator or a person who is not member of a legislature can become minister for a period of 6 months. After a period of 6 months, he cannot be reappointed. See, within period of 6 months, he should obtain the seat in the Vidhan Sabha or Lok Sabha, etc. If he fails to do that, he has to vacate his seat and go out. And there can be reappointment of the non-member. See, until that there was such a practice that reappointment of the non-member was something tolerated. But in S.R. Chaudhary's case, the Supreme Court categorically said that there cannot be reappointment of the non-member minister. See, how exactly the court arrived at that conclusion? if we read the judgment, we find that the court considered the basic philosophy of parliamentary democracy as practiced in United Kingdom and other countries. The historical background in which this particular provision was made, and the expectations of the people, and the purpose of this provision, etc. And the court said that we have to take into consideration all these factors, and uh, the application of that provision was to be limited to the purpose for which it was originally planned. That's why pluralistic argument becomes very much relevant, very much appropriate. See, in a AK Gopalan case, the relation between Article 21 and Article 19 was not taken into consideration. But within a few years, relation between Article 25 and 26 was taken into consideration in Sri Venkatramana Devaru case, the Mulki case relating to temple entry. There, the court examined that relation. Then, about the relation between Part 3 and Part 4 of the Constitution, there was a one approach in Champakam Dorairajan that Part 4 shall run subordinated to Part 3. But subsequently, there was a different approach in a Chandrabhavan case. There is a CB boarding and lodging case and a Kishananda case to the effect that Part 3 and Part 4 stand on equal footing. How exactly that changed? The court took into consideration different theoretical arguments and among different policies, which is the most appropriate policy or which is the most appropriate proposition. That was the example, and the court accordingly interpreted that way. Similarly, Article 368, that is a grand application of this pluralistic regime, because the text of Article 368 was considered. What is the meaning of the term amendment? In a part 20 of the Constitution, we come across one single article, Article 368, and that is the use of the word 360 and the word amendment. Whether exercise of this power of amendment under one particular part of the Constitution, Part 20, can undo the identity of the Constitution underlying in various other provisions of the Constitution? The answer is no. So, textual basis for a basic structure was established. Structural basis was also wanted. What is the relation between a power of amendment and other powers under the Constitution, or other provisions of the Constitution, or other responsibilities under the Constitution? The court viewed that multiple factors are to be taken into account. Structure of the Constitution should be examined. For the first time, structural argument was put forward before the Supreme Court, and the Supreme Court agreed with that structural argument, and that was a grand beginning of this era of structuralism. Maneka Gandhi and post Maneka development, all those structural principles emerged out of that. See, then we come across history. See, Constituent Assembly debates was examined thoroughly. Then foreign precedents were examined. They were taken into consideration. Then what is the ethos or the spirit of the Constitution? That was also examined. Then what is the morality underlying this power of amendment? Now, we come across one important observation by Justice H.R. Khanna to the effect that what morality will be there if Parliament enacts a constitutional amendment which provides that the membership of Lok Sabha and Vidhan Sabha shall be for life itself, and there will not be elections. What morality will be there? See, Is it in accordance with the ethos of the constitution? Is it in accordance with the morality underlying the constitution? The answer is no. See, moral vision underlying the constitution was pointed out by Justice H.R. Khanna. So we come across the multiple arguments: history, text, ethos, structure, purpose. All factors were taken into account. That's how this pluralistic theory becomes quite significant, and its importance is well demonstrated and vindicated, and that becomes essential. That's why in a number of judgments we come across multiple methods. See, after case Mananda, we come across a number of cases. It may be Coelho, Nagaraj, Chandrakumar, Mineral Mills case, election petition case. In all these cases, there is a reaffirmation of the principle stated in a Keshavananda. In all those cases, we come across application of multiple arguments in a constitutional interpretation. In an Indraswamy case, S.R. Bommai case, or a Puttaswamy case, also we come across multiple methods of constitutional interpretation. Thus, pluralistic theory is something established beyond all doubts, and it has enriched the constitutional jurisprudence very, very significantly, and it has become inevitable, and it provides a scope for growth of the constitution, expansion of its philosophy, and strengthening of its value itself. Now coming to the second part, eclecticism. The word may be a bit tongue twister, but we have to remember this concept. Eclecticism, it is a Greek word. Eclectikos is a Greek word, which means choose the best. Among different arguments, choose the best. There's the Greek idea. Etymologically, it has that meaning. Collins Dictionary points out eclecticism is the principle or practice of choosing or involving objects, ideas, and beliefs from many different sources. Choosing particular idea or belief or object as the most acceptable one. That is the eclectic approach. So, of course, it also means the fact of combining different areas or systems by taking into consideration best of a part of it. Stoics believed in eclecticism. They selected some of the theories which are considered as having highest possible degree of probability. There is the Stoic jurisprudence. Then Romans experimented with that. Cicero considered that in a constitutional republic, persuasion rather than power, rather than coercion, is the instrument of power. What is the instrument of power? Or what is the basis for power? Persuasion is the basis, not coercion, according to Cicero. And he built up this theory on the amalgam of work that emerged from the works of best men by uniting knowledge with the eloquence and liberal approach. In ancient Indian thoughts also we come across this eclectic approach. Which what can be considered as the best marga? See, Bhakti marga, Jnana marga, and Karma marga. See, among these three margas propounded in Bhagavad Gita, there are arguments which are pointing out the significance of each of the markers, each of the models. Yes, by selfless devotion, one can get a moksha, or it is by selfless work, honest work, that one can get a salvation, or one can get a salvation by attaining perfect knowledge. Among these three different ways of attaining moksha, which is the best one? That was the discourse we find in Upanishad as well as Bhagavad Gita. And ultimately they say that these three margas are synthesized. And these three margas are different layers of the same road. Different layers of the same road. So, it is possible to identify the relative validity of one marga with another marga, and ultimately point out how it is possible to make one marga compatible with another marga. Yes. See, there is one approach that one has to eschew bad association. See, satsangatve, nisangatve. See, one we have to have satsanga or good association with the good people. We have to do away with the bad association, and by that will be developing Nischala Prasad, and Jivan Mukti will also be possible only by that. There is a Shankaracharya's vision of satsanga and elevation of one's activities in such a way that ultimately he gets a salvation. See, eclecticism flourished in all the fields, almost all the fields of knowledge. See, in music it flourished by mixing Hindustani and Carnatic. Gandharva style of architecture emerged because of the synthesis between Indian and Persian or Greek styles of architecture. Then in philosophy or in say in various other discourses, for example, in all of this bhakti movement, we come across a syncretization or a combination of several viewpoints. For example, the views of Kabir, Nanak, or Sufi saints. They actually search for the best in each of the knowledge system and try to synthesize. Let's see what is the best and how to choose that best and how to combine the best of different forms. That becomes very much fruitful, and it makes an important contribution. See, we come across the mixture of different styles. See, in Indonesia, the Indonesian Supreme Court was built by mixing different styles of architecture, and there was one article which criticized that it failed the Indonesian architecture by a thoughtless combination of different styles. What is essential is that there ought to be a thoughtful mixture of different styles, otherwise will be nowhere. we have to take a precaution about the appropriate method of mixing various thoughts or synthesizing various viewpoints. That's the idea that we can make. See, so the ideal means that are evolved. For example, Trivarga principle that dharma shall stand superior to both human desires and economic processes or economic activities. See, there is a principle which is proved beyond all doubts philosophically, because it tried to uphold the primary values of the society. See, in India, we come across a application of this eclectic approach in different spheres, and about Hinduism also. It was observed by Privy Council in 1903 on the Bhagwan Koyer case that the Hindu religion is marvelously Catholic and elastic. Its theology is marked by eclecticism and tolerance and almost unlimited freedom of private worship. See, varieties of worship can be done within the Hindu fold. There's product for eclecticism. That's what is best is something can be invented by each individual, and he has a perfect liberty to do that. And eclecticism was practiced, and that is one of the essence of Hinduism. See, multi-form religious worship is something essence of Hinduism. That's what the Privy Council said, and Privy Council's observation is cited in a number of subsequent cases, and even in post-independence period, we come across such observation. See, in that judgment, it is also referred that yes, Hinduism rejects eating of meat of the cow, but chamaras are also admitted as members of Hindu food. See, there is that kind of balancing. Now, eclectic approach is something explained elaborately in jurisprudence. Augustine makes this observation. Eclectic legal theory is the approach to legal theorizing, where what seems best among various competing theories and their variants are selected to answer persistent and pressing problems in a legal theory. See, another explanation about eclecticism can be found in the constitution making processes. See, our constitution was forged by taking into consideration different ideas. Those ideas came from our own Indian soil, the indigenous viewpoints about say secularism, culture, or welfare and various other things. Similarly, the idea of a parliamentary form of government that was adopted with the changes. It's not just a application or absorption of the Westminster model as it is. They made some changes suitable to the Indian circumstance. Regarding the federalism also, they did not go for either the American, Canadian or Australian model. Of course, they went beyond the Government of India Act of 1935, and a different model was involved. But the ideas from different systems were taken into consideration. They were examined, they were thoroughly discussed, and ultimately the constitution makers they framed the constitution by examining all these factors. Of course, the American model of Bill of Rights was adopted, but all those inherent defects of American Bill of Rights was rejected. The American Bill of Rights has some inherent defects like a dichotomy that it is applicable only to the federal government, not to the state governments. Then it is not exhaustive. It does not contain the limits on those liberties, or it does not contain various specific aspects of equality, the positive aspects of equality. About that, it is silent. See, our constitution makers consider that relating to our problems like untouchability or forced labor, there ought to be specific constitutional provision. So they brought out a new set of rights. That's why Indian constitution is something different from other systems. Although the ideas of other systems were thoroughly examined by the constitution makers for a period of more than 2.5 years. They discussed thoroughly, but when it came to say incorporation of specific provisions, they were very cautious, and they involved that self-determination. Yes. It is not something just cobbling out from different systems. See, there are certain loose comments that Indian constitution is nothing but a set of principles borrowed from other systems. Very loose comment. It is a great disservice to the constitution makers, and it is a totally untruth, because the constitution makers did examine all these factors. They examined the cultural factors. When there was a discussion about the need to impose certain limits on a property right, some constitutional members cited from Shankaracharya, Bhagavad Gita, Artham Anartham. See, Artha will be give rise to Anartha in a Bhajagovindam. That sloka was cited. Bhagavad Gita was cited. It is a robbery to have property beyond one's need. See, it is an act of theft. That's what that was discussed. See, to say that they discussed only about eminent domain of the American system, etc., that cannot be regarded as a problem. They took into consideration all these factors. That's why when the constitution is a product of eclecticism, because the search was for a period of 2.5 years, a very thorough search. Which way to social revolution? That was the search. And when the constitution is product of such a thorough search and thorough application of different models, eclecticism is very much inbuilt in the constitution itself. So in the course of constitutional interpretation, to deny any scope for eclecticism is not appropriate. We have to take into consideration eclecticism, because what is the best is something to be examined by taking into consideration several factors. See, Gadboy, the famous American constitutional scholar, historian of the Indian judiciary, points out Indian constitution is Yes, a lengthy list of fundamental rights, American experience, then it has a board of judicial review, then it has a chapter on a directive of closed state policy, and thus it is primarily an eclectic document. It's an eclectic document according to Gadavar. Then in the case Puttaswamy judgment also we come across that observation that Indian constitution is an eclectic constitution. It takes into consideration various viewpoints and it develops on that basis. What could be the approach relating to application of this eclecticism? About this, we come across two approaches. One approach propounded by scholars like Bobbitt and Lawrence Tribe and also Randall Castro is that when there are several constitutional arguments, it is not possible to prioritize any particular constitutional argument as a superior over the other. Hierarchical treatment of these constitutional arguments is an impossibility. It is inappropriate because in a particular circumstance, which constitutional argument could be regarded as relevant is to be decided on the basis of its context, and it is not possible to go for one all-time theory which is applicable to all the systems. In one of the Australian cases, Justice Gummo makes this observation, a GS case. Questions of construction of the constitution are not to be answered by adoption and applicable of any particular all-embracing and relevant theory or doctrine of interpretation. It is not possible to have an all-embracing theory. See, one cap for all sizes is not enough. It's depending upon the context that you have to make a combination of different methods of constitutional interpretation. That is why Lawrence Tribe consider that ultimately the quest for a grand unified theory, or at least an overarching meta mode or meta principle, seems in vain on both as a practical matter and as a matter of principle. The appeal of all grand synthesis to the puzzled and uncertain has been all too familiar a feature of intellectual landscape throughout the history. Lawrence Tribe is also not in favor of treating various constitutional arguments in a hierarchical manner. Or he finds that it is not possible to go for a balancing, etc. But he also suggests that if it is possible to combine best part of one argument with the best part of another argument and produce a new principle of constitutional interpretation, then some rewardful consequences arises out of that kind of combination. That can be taken into consideration in some circumstances. But Bobbitt was not in favor of this approach, that there could be a balancing, because he said that in case of incompatibility between two constitutional arguments, then it is left to the discretion of the judge, and it is not possible to frame as a formula that a particular approach shall be adopted as a universal approach. It is not possible to lay down such a proposition. See, Randall Kelso states, with regard to constitutional interpretation, the judge must decide, among other things, how much weight to give arguments about the plain meaning of the constitution's text, the text's purpose or spirit, and historical evidence concerning the intent of the framers and ratifiers of the constitution. What weightage shall be given to the text of the constitution? What weightage shall be given to the purpose or spirit of the constitution? And what weightage shall be given to the historical component? All these types of things are to be left to the discretion of the judge, and it is not possible to lay down a straight jacket formula which will simply deny discretion to the judge, because every judgment, every case is to be decided on the basis of the context. In contrast to this viewpoint, there is another viewpoint that we have to go for a prioritization. We have to go for a combination. Richard Harlow, Dennis Patterson, and Jefferson White were scholars in support of this proposition. See, according to Fallon, by hierarchical treatment of constitutional arguments, it is possible to find out which is most commensurable, which is appropriate, or which could be adopted. See, that hierarchical treatment can be illustrated. For example, in a Dobbs case, there was a overruling of Roe versus Wade. Dobbs case is the latest case relating to constitutionality of legislation regulating abortion. After a period of 50 years of Roe versus Wade, the American Supreme Court rejects Roe versus Wade. It overrules that judgment and lays down the judgment that there is no right on the part of a pregnant woman to make such a choice which will come in the way of the right of the unborn child, etc. See, here the argument that prevailed in Roe versus Wade, and also for a period of 15 years, with certain challenges in between, was considered as a not applicable or not appropriate, because the text of the Constitution does not recognize right to abortion. Is it a part of a ordered liberty of a civilized nation? Was a question. By applying Palco versus Connecticut principle, ultimately the court said that it is not possible to recognize a right to have abortion as a right recognized under the Constitution. It is not at all recognized. And hence, Roe versus Wade was a erroneous judgment, egregiously erroneous according to Justice Alito. And he viewed that it went against the text of the Constitution. So, when in a Roe versus Wade, it was the spirit of liberty that dominated the mind of the judge. In a Dobbs case, we come across the text of the Constitution which prevailed on the mind of the judge. See, when there is such a scope for different approaches, such a prioritization should be made possible. Of course, in the first judge's case, the Supreme Court said that the Chief Justice of India has only power of giving advice. That's all. His advice is not binding upon the president. Like any other appointment, here also president's appointment is an exercise of executive power. Yes, depending upon the suitability, he has to decide. That's all. But in a second judge's case, the court overruled the first judge's case and said that the Chief Justice of India has a positive role to play, and his consent is a must for any judicial appointment. See here, in the second judge's case, history was preferred over the text. Textual argument was one, that consent means only consent. That's all. Consent is not a meaning of consent. But when, because of the historical genesis in the Constituent Assembly, even before Constituent Assembly, and after the commencement of the Constitution, for a period of more than 50 years, continuously, when there was this kind of constitutional convention itself, that's followed in a religious manner, then it ought to be considered that consent of the Chief Justice is mandatory before appointment of the concerned person as a judge. So, preference is shifted from a text to history. There was such a shift, and Richard Fallon points out that there is a scope for hierarchical treatment of these constitutional arguments. Depending upon the context, the court will decide. There is a view promoted by Robert Post in favor of this choice between theories or choice between arguments on the basis of certain criteria. See, when theories of the Constitution are modulated, and on that basis, the nature of Constitution is also built. It is essential to take into consideration the importance of those theories. For example, related to dignity, Aaron Barak's view is that views of society's bedrock views shall be the basis for a choice of that concept. Concept of dignity is something that could be drawn from the society's bedrock view, that without a dignity, there cannot be a meaningful human life. That is a bedrock. See, even related to international human rights, the basis for a human right is a dignity. How exactly this human dignity was taken into consideration from the angle of a culture, from the angle of time and legal context. About this, Aaron Barak views that various controversial issues relating to right to die, right to have abortion, or right to have same-sex marriage. These types of issues are to be ultimately decided on the basis of human dignity. And what is the dignity is something that decided on the basis of that society's basic understanding. It's cultural approach or its basic understanding of our dignity. See, same-sex marriage was considered as valid in America, Australia, Canada because of their cultural environment and legal uh, preparations for upholding the liberty of the individuals. But in an Indian context, the same argument did not hold good in the latest Supreme Court judgment. Supriya Chakravarti. See, a modern humanistic approach is to be taken into consideration in examining what is the basis for human dignity. Thus, even related to the same concept, human dignity, different interpretations may be possible. In a different cultural context, different countries, or different time scenario. Ultimately, it is by taking into consideration the bedrock views of the society that the court has to decide. That is the view of Aharon Barak. Aharon Barak is a very eminent scholar, was a former Chief Justice of Israeli Supreme Court, wrote a very important book like a purposive interpretation. And yes, about judiciary also, he produced a recent article and a recent book. Very eminent scholar. See, thus, there are basically two arguments. One argument saying that it is not possible to prioritize or hierarchically treat any of the arguments. The other argument is that it is possible to bring coherence. If it is possible to have such kind of a coherence, that can be attempted. Now, let us look into the practical application of eclecticism in different countries. Firstly, in India. See, searching for the best approach among the multiple modalities of arguments, trial towards their hierarchical formulation and effort to integrate them are not very much explicit in the Indian constitutional jurisprudence. We will not come across a number of cases relating to eclecticism, but we come across, at least in some cases, how eclecticism is attempted. But we find that major breakthrough in a constitutional jurisprudence occurred when the court went for application of eclecticism. See, about the parliamentary democracy's supreme power to amend any provision of the constitution is one line of argument. The court rejected that argument in the case of the case. There will be multiple arguments, but the court cited or the court rejected that textual argument. The court took into consideration a different line of argument by combination of the wisdom of different constitutional arguments, and that's how a big breakthrough in a constitutional jurisprudence took place. See, the word eclecticism is used very rarely in Indian judgments, but in some of the judgments relating to minority right to education under Article 30, Clause 1 of the Constitution, we come across a reference to eclecticism. Chief Justice Das in a Kerala education bill case pointed out the need for keeping the minority right a real one, not a not an imaginary. And he also stated that right to administer does not include the right to maladministration. Maladministration not only marks the very functioning of that institution, but also brings bad things to the society, or it has an adverse impact upon the society. That is why maladministration, even of a minority institution, ought not be done. That is a deep point. Elaborating on this view, in a Saint Xavier College case, Chief Justice A.N. Ray makes this observation. The right to administer is to be tempered with regulatory measures to facilitate smooth administration. The best administration will reveal no trace or color of minority. A minority institution should shine in exemplary eclecticism in the administration of the institution. It should shine in eclecticism. That's by bringing best of its function, best of the management, or best of service to the society. It should shine. So the word was used in that context, and that concept has its own implication, because how exactly the minority education institutions shall be administered. About that, we come across different viewpoints. For example, in a Gandhi files a case, Justice V.R. Krishna makes this observation. There are two extreme ends. One is a hands off administration. Another is a handcuff to management. Hands off to administration. Anything can be done. See, you have a free hand to administration. Then there is one thing. Handcuff to management. Everything is to be timed. Everything is to be regulated. There should be point to point scrutiny. That is also called as a mother-in-law scrutiny of the act of the concerned institution. See, both are incorrect. A benignantly regulated liberty, which neither abridges nor exaggerates autonomy, but promotes a better performance, is the right construction of the constitutional provision. Such an approach enables fundamental right meaningfully to fulfill its traced with the minority's destiny in a pluralist polity. This is the authentic voice of Indian democracy. To regulate, be it noted, is not to restrict, but to facilitate effective exercise of the very right. The constitutional estate of the minorities should not be encroached upon, neither allowed to be neglected nor maladministered. That is the way in which he brought eclectic idea into the administration of minority institutions. We come across different types of experiments in a minority education institutions rights. See, teachers and staff shall be adequately protected, their welfare shall be promoted, or non-minority children shall also be accommodated in admission. See, a minority institution shall have sprinkling population of non-minorities. In case that minority institution gets a grants in need. See, all these were outcomes of experimented about the best form of management or best situation. See, once maladministration is excluded, then comes the question whether a commercialization could be introduced. And in the 1990s, that argument started. See, in Unni Krishnan case, that distinction between payment receipt students and merit students. That was the experiment. See, we have to understand the context. It was the beginning of globalization and how privatization and globalization is being introduced. Because India had to prepare itself for the new millennium of creating a lot of graduates, either in the medical world or in engineering. And of course, that problem continues. NEET and other controversies are there. See, in that context, the court evolved. I'm quoting. Experimented with a new idea. That's a distinction between a management seat and a merit seat, or a payment seat and a merit seat. See, related to minorities, the 50-50 formula, or the not 50-50 formula of Muda, 50-50 formula of education institutions, which was proposed by Justice Jagannath Shetty. Yes. He pointed out that the number of non-minority students shall be to the extent of 50%, whereas minority students, their number should also be similar to that. And between Article 29(1) and no 29(2) and Article 30 Clause 1, the balance could be established only by that. See, both these approaches, Unikrishnan approach and Stephen's case, both approaches were rejected in the TMA Foundation case. Why Foundation case was another attempt of balancing between globalization, individual rights, collective rights, etc. And of course, there also the court excluded the possibility of making a non-funded private education institutions to bear the burden of providing for a reservation to scheduled caste, scheduled tribes, etc. In PA on the case that approach came. To counter that, an amendment was brought. Article 15(5) was introduced, and obligation to accommodate the reservation for scheduled caste, scheduled tribes, OBC. That was done under Article 15(5), and this was again examined Pramati Education Trust case. There the court considered that the minority institutions shall have autonomy and their interests cannot be jeopardized, etc. See, all those experiments, there's of course, first started with the Moini Jain case, that even related to medical college, there shall be perfect right to equality, and Article 21 is applicable, etc. That was subsequently modified. So we come across this continued application of this eclectic search by the judiciary in a Janahit Abhiyan case. The basic structure validity of Article 16 Clause 6 was examined. There is a EWS or economically weaker section reservation. There, the Supreme Court upheld the constitutional validity of this provision. See, it was argued that when SCBC, OBC, SCs, and STs are given reservation, there is no scope for EWS because they are already covered under these categories. But which could be an appropriate argument. See, when economically weaker sections who are not coming under any of these categories are to be given certain remedies. Then there ought to be such a provisions, and it cannot be regarded as a improper. In a subsequent case also, there is an approach that a constitution is an organic document, and the EW is something that ought to be accommodated, and of course, Indra Swani case, there Justice Jeevan Reddy makes this observation. We have to find, and we have tried our best to find. See, we have tried our best to find answers which are, according to us, are the right ones constitutionally and legally. See, of all the judgments relating to reservation, Indra Swani ought to be considered as a more sober, more reasonable and appropriate decision, because it imposed limits on extent of reservation, not beyond it. It introduced the concept of this yes, creamy layer test. Creamy layer test. It excluded reservation for yes, reservation for a highly specialized posts like a scientist, professors, or such eminent scholars. About that, there cannot be reservation. Then, of course, there shall not be reservation for at the level of a promotion. That was another provision. In a subsequent judgment, there was an effort to dilute or say dismantle all these propositions. But in a M. Nagaraj case, there was at least some effort of protecting the basic ideas of a Indra Swani case and limiting the scope of those amendments. See, when a socio-economic changes take place, yes, there ought to be adequate legislation which are brought for say decentralized distribution of resources, and in one of the cases, there's a Maharashtra State Electricity Board case. There the concerned legislation provided for fixation of compensation in a manner not on just and equivalent lines, but at the lower level, so that the economic change occurring through such a legislation to be properly accommodated. See, concerning this, there was a view promoted by Justice M.N. Venkatacharya that when socio-economic changes take place and under Article 39B and C, certain special protections are there. It is essential to recognize those points. Then we come across the famous search for appropriate line of reasoning in a Keshwana case, which is appropriate. Here, the text of the constitution, there's the word amendment, was not literally interpreted. It was interpreted in the light of other provisions of the constitution. Then this eclecticism continued even in other cases also. NJS case and other cases will continue. And there is one scholarly argument by Chintan Chandrachud, Dr. Chintan Chandrachud. He argues that there are anomalies as a result of creation of smaller benches of the Supreme Court. Because of that diversity of different viewpoints emerge, and it is not possible to have an appropriate understanding of the concept, and of course inconsistency between a Suresh Kaushal case and Nalsa case, and Lily Thomas case and Nota case. All these uh, different viewpoints given by smaller benches of the Supreme Court, which are not very much convincing, which are providing for different viewpoints. That was a pointed out by just yes, Dr. Chintan Chandrachud, and about the approach adopted in the Kohelu case and other case also, he makes certain comparison in the discussion. Points out that the reasoning relating to eclecticism is not rationally developed in the Indian context. The idea of eclecticism is not a well developed. Of course, we come across some judgments where reference is made to that concept, and the overall development has its own implications. Now, coming to the comparative position, let me briefly point out that in America, eclecticism had a very, I mean, it had a bad experience of accommodating slavery also. See, there, in a Dred Scott versus Sanford, the American Supreme Court upheld the rights of the slave owners or the slave masters against the slaves, and the legislation enacted by Congress to make the slaves escaping from a slave state to non-slave state free was declared as unlawful. See, there the Supreme Court considered that the African Americans were not citizens of America. They are not the citizens of America altogether, and it is not possible to extend any of the rights under the Fifth Amendment to such slaves. That was the proposition. But what is the best argument? That what would have been the best argument? Of course, the dissenting view is quite clear. No, they are also human beings. They are also citizens, and the ethos of the constitution is to provide liberties to all citizens, and the idea of the citizen is to be understood in a general sense, etc. That's the dissenting view. Eclecticism allows scope for such counter arguments, and dissenting views are quite important propositions. In the same way, Plessy versus Ferguson, when the majority said that the separate but equal doctrine is something appropriate, it is well within the constitutional framework, etc. He sold the dissenting judgment by Harlan, and he pointed out that yes, our constitution is a color blind. It does not know differentiation on the basis of a color. And yes, color of the skin is only skin deep, and inside the skin there is a precious human worth, and that is to be taken into consideration. See, these dissenting views challenge the majority views, and in a lot of research in New York also, majority was something in favor of the contractual rights, and it was against the liberty rights. But subsequently, it was overruled. see, such a scope is there for appropriate values. In Australia, we come across application of eclecticism because of that, in the absence of a formal constitutional bill of rights, the Commonwealth judges consider that it is appropriate to apply the general principles related to parliamentary democracy to recognize freedom of speech and expression. Because without freedom of speech and expression, it is not possible to have a parliamentary democracy at all. So, eclecticism had that kind of a positive contribution to make in Canada after the concept of Canadian Charter of Rights and Freedoms. Eclecticism has become day-to-day practices. They had that good background of this living tree concept. And after 1982, by looking into the experiences of free democratic societies of civilized nations, these are the words prescribed under the Constitution itself. The court is compelled to look into such a types of examples. So it's by looking to such examples, best practices that the constitutional jurisprudence evolves and develops. Because for a form of government that defaults context, that which governs best is the best. See, Alexander Pope in his couplet, he makes that observation. There will be presidential form of government, parliamentary form of government, or say semi-presidential, etc. For the forms of government, let the fools context. That which governs best is the best. In the same way, when we search for the best of the values, we have to keep in mind how exactly the choice of the best principles can be done by taking into consideration competitive arguments and the marketplace of ideas, that which is best and that which can hold itself as a valuable, that ultimately gains. Thus, a pluralistic argument is an argument which provides a scope for varieties of arguments, whereas eclecticism is one where we are made to think about the best one, and in various fields we think about the best choice, whether it is metaphysics or day-to-day life, family life, or any other thing. We choose about the best. So that urge for getting the best form is something that ought to drive the constitution. With this, I am concluding. Thank you very much for your attention.
Thank you so much, sir, for your detailed thoughts on the constitutional interpretation. It was indeed a profound session. Thank you so much.